Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation. This video is going to focus on a recent court decision out of Florida that's an intersection of two videos we've done. The first video we did was on sovereign immunity, and if you don't want to go back and watch that video, sovereign immunity is the legal theory that the state and local governments are immune from any liability unless they specifically waive that immunity. The second video was on Florida PIP subrogation and the right of reimbursement against commercial vehicle owners or their insurers when a PIP policy pays for injuries to a passenger in that commercial vehicle or pedestrian that was struck by that commercial vehicle. Previously on this issue, there was a decision out of the 2nd District Appellate Court in Florida that said a PIP carrier has a right of reimbursement against school boards, and they found that there was a waiver of immunity and therefore that right of reimbursement existed. The recent case that came out at the beginning of July 2024 was out of the 4th District. This was a series of cases against Palm Beach and Broward County school districts for the same scenario. Injured parties on a school bus, and those PIP carriers were seeking reimbursement from the counties. The court came out with a different decision than the Lee County case, and it found that there was no waiver of sovereign immunity. The basis for this waiver of sovereign immunity was found on looking at what is required to waive that immunity. And they need clear and unequivocal waiver of immunity, and the court was not willing to infer that there had been a waiver. So the court laid out, looking at other cases, specifically where there was a finding of a waiver of immunity. And those cases focus on the identification by statute that the state or local government was an entity that could be sued. And it set forth a couple of examples from the workers' compensation law and the Florida Civil Rights Act that stated that the state could be sued for a violation of those statutes. Looking at the statutes regarding PIP reimbursement, the court found that while there is the statute that says that public school buses are considered commercial vehicles and therefore would be subject to that statute of allowing reimbursement against commercial vehicle owners, that they weren't willing to infer a waiver of immunity. And specifically, there's nothing in any of the statutes that say that the state may be sued. The court went further on to say, look, a county school board may decide to outsource or contract with a third party. And if that third party isn't protected by sovereign immunity, well, that third party that provides the public bus transportation could be sued. So even though public school buses are considered commercial vehicles, there was nothing in that statute that created the waiver of sovereign immunity. So that led the court then to say, since there's no waiver of sovereign immunity, school boards and counties are protected from PIP reimbursement claims under that commercial vehicle exception. So where does that leave us now? We have the Lee County case from 2019 that said there was a waiver of sovereign immunity and PIP reimbursement was appropriate and allowed. Now we have the 4th District that says, nope, there was no sovereign immunity waiver. The next logical step is it's going to go to the Florida Supreme Court to resolve this dispute between the districts. Now, if you currently have a PIP reimbursement claim and you're seeking reimbursement from the school district or school board for those losses, at this time, while it's in limbo and we have the conflicting disagreements between the two different districts, it's unlikely that you're going to get any movement from a school district on these issues. They're going to wait and see if this goes to the Supreme Court and how the Supreme Court rules. I'm not going to guess at which way the Supreme Court will go, but if they do rule that there is sovereign immunity and that there was no waiver by these PIP reimbursement statutes, well, then that's going to end the right of recovery against school districts for PIP in Florida. However, if the Supreme Court comes back around and says, no, there is enough to infer a waiver of sovereign immunity, that is going to allow them to proceed. So stay tuned to On Subrogation. We will continue to keep you updated on this very interesting legal issue, and there's certainly a lot of cases that this applies to, so it's important to us as well as you. If you have any questions, feel free to reach out to us at video@rathbonegroup.com. And for On Subrogation, I'm Jason Sullivan, and that's the long and short of it.